Hello.
Oh, it's on. Okay, live.
Hi, everyone.
Hello.
How's it going?
Okay.
Should we begin by introducing ourselves?
Yeah, that's a great idea. Ladies first.
Okay. Hello, everyone that's joining, and my co-panelists. I'm super happy to be here. My name is Bianca. I'm a lawyer, NFT, crypto, blockchain lawyer in Montreal, and I'm also the co-founder of the first NFT or crypto art gallery in Canada, which is also located in Montreal. I wrote a thesis in university about how to authenticate art with blockchain, and that's where the interest for copyright and blockchain really appealed to me. So lots of interest for that for sure. And I'll let my fellow panelists introduce themselves, and then we can go over these interesting questions.
Sure. Manfred?
Sure. My name is Manfred. My background is mainly in finance. So I'm an investment banker and a public market investor, not a lawyer. I spent the last 3.5 years at Atari, both on the group strategy, corporate development side, and more recently on all our blockchain efforts, including NFTs, metaverse projects, Sandbox, Decentraland. I'm currently an advisor to Liti Capital, which is a litigation financing firm here in Geneva, where I'm based. And on a personal level, I've also fallen deep down the NFT collector rabbit hole. So I've been collecting mainly NFT art for the last 18 months or so. And so I also have more of a user background, but especially from my Atari perspective, obviously we deal a lot with copyrights, licensing issues, both in our main business and it's interesting to see how that translates to Web3, where obviously the framework is a lot more still to be written.
Dave, please go ahead.
Sure. My name is Dave Rodman. I am the founder and managing partner of the Rodman Law Group. We have been practicing in the blockchain crypto space since late 2016. It is our biggest practice area, and it is where I spend all of my time, both professionally and personally, as I am a DeFi degen and an NFT collector. As you can see on my wall, I have a party bear at the moment displayed right behind me. So shout out to Fluff World. But yeah, we basically serve as outside general counsel for projects in all verticals in the blockchain space, from L1s to NFT based projects to decentralized finance protocols. And it's an amazing time to be a lawyer in the space. It's a little maddening. I can kind of feel like Chicken Little sometimes with my clients, but it's really rewarding.
Okay. Hello, everyone. It's a real pleasure to be here today. I'm actually based out of Hong Kong. So right now it's about 11:17 p.m. In the evening. Not too late for me at the moment, but you get later. But essentially, I'm currently the group CEO of a group of technology companies that are headquartered in Singapore, where the research and development is based out of Hong Kong. But we have 2 subsidiaries that are actually listed on the OTC markets in the US. So we actually have to, on a day-to-day basis, deal with regulators out of the US, as well as regulators out of Singapore and Hong Kong, which are actually Commonwealth countries. So these are 2 very different regimes, something I'd like to talk about a bit later. And although I'm not a lawyer today, I was actually a lawyer by training. I was legally qualified in Singapore, Hong Kong, as well as the UK. But of course, I'll leave most of the legal discussions to Bianca and Dave and try to tackle any questions that there may be, really from a business perspective. So that's just a very brief introduction of myself. And let's kick off with whatever questions there may be.
So I think we have some sort of primer questions here. And the first one is, can NFTs be considered securities? I think the answer to that, I mean, is that cool with everybody if we jump in on that one?
Go ahead, Dave.
I think the answer to that is absolutely 100%. Anything can be considered a security if it satisfies the Howey test, at least in the United States. And quite frankly, the SEC has stated publicly that they are investigating NFT raises because it's, you know, in the same vein as the ICO boom. A lot of people have realized that they can raise a lot of money with NFT drops. So I think maybe a third of the calls that our firm gets these days are people asking us how to go about doing an NFT drop. And basically my advice is, look, if you're going to do it in the United States, and that's a big if, you have to recognize the sales as income. You cannot treat that as investment income. Otherwise, you are engaged in the unregistered sale of securities. That being said, we like to move all of our crypto projects offshore into some very unique structures because of the uncertainty around these things, and because, quite frankly, offshore jurisdictions have favorable tax treatment. But NFTs can be considered, in my view, they can be considered relatively vanilla from a regulatory standpoint, but the intention behind them, the rights that they grant, the way that they are marketed, these are all things that can lend to a very easy finding that your NFT drop is a security. You know, it's all in the marketing and the packaging.
I'm interested to know what you think, Dave, about actually OG NFTs, since this is the discussion today, and securities law application for OG NFTs that currently most people are using as investment purposes. And the application of the Howey test for that.
So by OG, do you mean projects that were launched, there was nothing really special about them, and then they tickled an itch and all of a sudden became very, very popular, and then after the fact, their users have been granted things because of holding them?
I think OG NFTs like CryptoPunks, Bored Ape, like the first big collections that are now like that have made a lot of profits for some people. And I know like people who buy them, they buy them for profit, right? They it's an investment. So yeah.
Yeah, so I think that that's a really good jumping off point, because I would call those organic projects, in that they were launched, there was nothing special about them, maybe there was some lore involved, but they were really kind of an experiment, and they got very, very popular, and thanks to the royalty cut on OpenSea, the actual projects have a ton of money. And so then they started to reward their customers, their holders, and like that to me is a very organic and freedom of contract type scenario. People had no expectation originally when these were all minted of future profits. I mean, maybe they thought they were going to go up in value, but there wasn't I bought this because I know I'm going to get that. And so a lot of projects that are starting look at those initial organic projects and say, oh, I want to do that. And then they market to that. And they say, oh, if you buy this, you'll get access to this party in real life. You'll get whitelisted on XYZ. You will get an additional drop, or the one that kills me is you'll get passive revenue. And that those are all securities. Well, at least most of those are securities. And some of them kind of walk the line of whether or not they're securities. But I think there's a huge difference between a project that was just put out, got huge, and then after the fact, the project rewards its holders. You know, that was not why people bought it originally. In the initial mint, when it was company to the public, it's not why people bought it. Now, people may buy it now for that, but those sales are largely happening in the private markets. So it's covered by, first sale doctrine, freedom of contract, whatever you want to call it. It's art collecting with a plus. But when you try to replicate that inorganically from the get-go, that's when I believe that projects have a lot of potential issues.
Yeah, I just wanted to echo what Dave just said. I mean, all of the discussions I've had with our US counsel, Dave is absolutely right. I mean, anything can be a security based on how it's tested, and it's actually very, very broad. As long as there's some kind of an enterprise, and enterprise doesn't mean a legal entity of any kind. It could be a project, and as long as someone else is managing it for the expectation of some kind of returns, that could be deemed to be a security. But I just wanted to add a little bit more to what Dave has said from a UK law or common law, Commonwealth countries perspective, which is actually a little bit easier to navigate because essentially from a Commonwealth country's perspective, we usually look at two specific definitions whenever we think about whether something is a security. The two main definitions that we deal with, one is whether it's a derivative, and the second one is whether it's a collective investment scheme. So for derivatives, it's actually very simple. As long as the asset that you're selling, its price and its valuation is dependent on another underlying asset. So a very simple one would be an equity-linked swap. Manfred is an investment banker before, so he would understand what I'm saying. That would be a derivative, right? And the question is, if you had a token or an NFT in this case linked to an artwork, and the value depends on the underlying artwork's value, would that actually constitute a security? I think that's a bit of a stretch. I don't think so, but again, that could be arguable. The second one is a collective investment scheme, and essentially what it means is that if a lot of investors are pulling their monies together, so that someone else could manage that money for the intention of actually generating a return, that would also be constituted as a security. So just want to add that part from my perspective. So there are two regimes here that we're really, really very concerned about. And this is something we're navigating around every day. But thank you.
Okay, I think we have some questions in the chat. How do you deal with copyright infringement in a decentralized world? And that's a super interesting question, since it's been happening in the past few months. We've seen it. A lot of companies are trying to either protect their IP, and some have just abandoned it and decided that they were not going to fight for it. And we've seen that copyright concept is changing a lot. Like how you should protect your IP in a decentralized world is definitely going to change. And I'm curious to see what you guys think about that. Maybe Manfred.
Yeah, that's a good one for me, because that's definitely something that we're confronted with. My previous job at Atari, where a lot of our work is actually protecting the brand, because the value of the brand, obviously Atari, it's like one of the iconic brands in video gaming, and the logo, the Fuji, is very popular. You see it on t-shirts, sweaters, everywhere. And what you have to realize is that a lot of the products you see on the street are not licensed products. So we take a pretty strong stance on copyright enforcement, especially in the US, where the laws are obviously very strong, and Atari is an American brand. So the good news is, in the Web2 world, so Atari went after a number of, for example, platforms like Zazzle, others like T-shirt on demand printing services, where anyone can upload a design, get a mug printed, a T-shirt, and the onus is on the platform to actually monitor that you're basically not infringing on someone else's IP. And so obviously there's a lot of potential for infringement, but there's a pretty simple remedy. You notify them that there's infringement happening. You order them to basically clean up their shop, and if they don't do, then you file a lawsuit. And generally, the penalties can be pretty dissuasive. So we've had pretty significant settlements for people who were infringing for a couple of years, and so it's not something that you recommend. In Web3, clearly the subject is very, very delicate. And yes, same thing. We've seen that there are, for example, some artists that would use a historic Atari console and basically do whatever, a Nintendo Game Boy and a PlayStation, and sell it as an art NFT. obviously you're not going to go after this because you can argue it's fair use, you can argue it's an artistic work, but if somebody's trying to obviously make like commercial profit out of your brand, then it becomes more difficult. So especially you can have anonymous projects. You can have basically in this permissionless world, you can have people minting NFTs on OpenSea behind a wallet that can be funded from sources that are hard to track. And how do you go after this? So the only way that the only real debate that's been happening is like, how hard should you be on derivative projects or projects that are inspired by other projects? But that's more, I would say, for collections, like you've seen it with Cyberpunks or others, or these kind of things. So you've had different approaches, some that were pretty like strict, where basically you'd issue DMCA takedown notices to OpenSea, and that's pretty much the only remedy you have. But clearly, it's a pretty strong remedy with OpenSea being such a dominant platform that if a project gets basically delisted from OpenSea, all the people that have bought the NFTs, they're usually instantly in a position where they have financial harm because there's no liquidity or very little liquidity. So that's kind of an interesting approach. But more in the ethos of Web3, an interesting debate that's been happening. But I think for corporates and brands, really impossible. But for a lot of these organic projects, it's some of them have gone the kind of rights-free mode where derivatives are encouraged, because at the end of the day, they're going to basically improve the brand perception and awareness across the space, and that's nothing to do. And then there's others where they're again very strict and they say, okay, we don't want this. We're going to basically issue takedown notices everywhere every time we find it, and there's no right or wrong approach, I think.
Well, I don't know what I missed. Sorry, guys, for blinking out there. I have no idea why that happened. But I think so far my favorite example of this is Nike's purchase of Artifact. There's all this language about fractionalization. And then like the day that it closed, Vincent Van Gogh fractionalized an Artifact piece and was like, tweeted it at Nike and at Artifact. It was like, come at me, man. I'm an anonymous Twitter user. And I think that's a perfect example of how the incentives have changed in Web3, and that traditional brands are going to be very slow to adopt these things. I mean, just think about it from a legal standpoint. They probably paid their lawyers, what, $1,000 an hour for a month or so to maybe longer to get that licensing agreement and sale all put together. And then day of, somebody does the exact thing that they say that they're not supposed to be able to do, and there's literally no way to stop them. So I find that very interesting from a legal standpoint.
Yeah, I think it's mostly strategy for brands to decide if they want to fight or if they just want their brand to be accepted by the Web3 community, because that's what we feel in the community. People tend to just prefer brands who will let them do whatever they want with their IP. So I'm curious to see what other brands will do and how that will evolve.
And I just want to add, a little bit from the NFT holders' perspective. We've been talking very much about, how brands' intellectual property could be infringed. But I think a lot of NFT holders would love to know how they could protect whatever intellectual property they have with respect to the NFT that they're holding. Whether it's a CryptoPunk, whether it's a Bored Ape, as Bianca mentioned earlier. I think what is very important when you're buying any NFT is to ensure that you actually get what you're asking or what you're actually buying, right? And one of the things that must be very important must be the intellectual property for the image that you're actually buying. And a lot of people get themselves into a difficult situation where they buy an NFT without actually doing the research as to whether or not it comes with any kind of copyright or any kind of a licensing. And that becomes very problematic at a later stage, because then you will have no authority and no legal right whatsoever to take any legal action against any breach of whatever intellectual property that you think you have. And I think that's something that's quite important. So personally, number one, I would make sure that the intellectual property comes with the NFT. And number two, if possible, make sure that the intellectual property agreement is actually in the metadata of the NFT, in which case then you're definitely fully protected rather than a separate document. But that was just my 2 cents on this point. Thank you.
Yeah, I mean, I think that the ultimate answer here is that there needs to be an API plugin with the U.S. Copyright Office, and I think that like 3 to 4 years from now, maybe 5 years, this could be a reality. But yeah, until that happens, you're relying on whatever sort of licensing there might be in a terms of service, and then you can't. Like, I'd be really interested to see what happens with the individuals who are using their apes to do other things, you know, make bands, or Jenkins the valet, where the license says that they can do that, but the law says in order to litigate and enforce your copyright, you have to have a copyright that's registered. So yeah, there's going to be some scrambling, I think, as people put more money into their individual, maybe NFT-based brands that are being created.
Another question we have: when and how does art come into public domain? And so that will be different based on the jurisdiction where you are. Typically, it ranges from 50 to 70 years after the death of the author or the creator of the artwork. And that's a very...
Unless Disney manages to increase the time again.
Yes. So, of course, law always comes with exceptions. And I think that's something really interesting, because we have a lot of people coming to us either at the firm or at my gallery asking if they can create NFTs with traditional paintings or artworks that they don't own. Like, they own them on their wall, but they don't own any copyright on these artworks. And it's been a challenge, because these people really do feel like they own the painting. It's been in their family for years and years and years, but there's still copyright on that painting. So what can they do with it? Can they create an NFT with it? And the answer, obviously, there's many exceptions, but ideally, you don't want to risk that. At the risk of being caught by the estate, even if the author is dead, it can be very risky. And yeah, curious to know what you guys think about this, how to deal with that.
Well, I mean, there's the fair use exemptions that everybody thinks they can use that are way harder to use than they actually believe. But if you're somehow providing commentary on the piece by changing it in some fundamental way, which I'd argue making an NFT of it is not enough to satisfy that criteria. But if you were to be able to do it, and it does satisfy like the satire or the commentary component, then you could claim fair use. But if you're trying to make a one-of-one of a painting that's been in your family for years, yeah, you'd better reach out. I mean, I tell people all the time, you have to make sure you have the rights for this, because if you put it out there and it's floating around, that's multiple, depending on how a court looks at it, that could be multiple cases of infringement, and that can add up very, very quickly in the terms of dollar penalties. And let's face it, courts are not going to be super enlightened on this point. Most judges are, in their 60s and probably aren't. I mean, lawyers as a whole, we're not exactly the most tech forward group in the world. And then judges are just exponentially worse. So I think that there's going to be some pain for people who are just minting willy-nilly things that they can mint because they think that the law doesn't apply to Web3.
Yeah, I can only speak from a more like NFT art collector perspective. I think what really makes art NFTs and what made them really interesting and relevant is that actually NFTs became like the native medium for a lot of like digital art, basically, that did not exist in the physical form before, whether it's generative art or even what Beeple was doing before, where it basically resided on ArtStation and Behance and whatnot. And suddenly there was a way for people to collect these artworks. And what makes them special is clearly kind of the rarity element, like the signed print equivalent in the art world. So for me, the question about I own a Warhol, I have a Warhol painting in my family, and I want to make an NFT out of it and sell it. From a collector's perspective, I'm not really sure who would actually want to own that as an NFT, because it's not native to the format and it has no value. The value in the NFT comes from the fact that it is an NFT first and foremost.
And I think a lot of the value also comes from the reputation and the reputation of the artist or the company selling that NFT, because it's, if whether we want it or not, buying NFTs is some sort of an investment. So when you buy an NFT, you want to make sure that later on it will have value and you can resell it. But if some random dude sold you that NFT, then how are you going to sell that again to someone else? Like, how are you going to convince that person that it's valuable? You break the chain of provenance by minting an NFT that either you don't own or have no rights on. And breaking the chain of provenance is automatically going to break the value. So that's very important to keep in mind.
It kind of defeats the purpose from a collector perspective. So, but there are some counterexamples. For example, it's true that the British Museum did an interesting experience where they sold NFTs of the Great Wave of Kanagawa, the Hokusai painting. And there, I think it's interesting because obviously the issuer, the seller, is a legitimate institution, and obviously it's in the public domain. But there, I can see how, as a collector, you may think, well, the provenance is kind of there, and this thing can indeed stand the test of time. But that's a special case. I think coming from a private kind of individual, it's a lot harder to have that level of trust.
Yeah, that's true.
There's a question about collaborative artworks or NFTs, which an artist creates for a brand or a company. We haven't addressed that yet, have we?
Nope.
No.
I think I could speak to this from the company's standpoint. I mean, we strongly encourage our clients that do anything generative that requires like the creative input from a third party to have very strong works made for hire contracts, so that the artist can't assert some sort of claim on a generative project of 10,000 items that they designed a part of that got used. It's amazing how frequently that is overlooked. And I mean, for all of those artists out there that have done something like this, like, not to be a copyright troll or anything like that, but you probably have some sort of claim to ownership if there was no clear delegation of rights in the statement of work or the contract that you signed. So we are adamant that all of our clients that use these sort of mechanics button up their relationship with their artists to make sure that sort of thing doesn't happen. I don't know if anybody wants to speak to that from the other side.
Yeah, I think from a corporate side, it's standard. Yeah, it's kind of
yeah. I mean,
standard
from a company's perspective, Dave, you're absolutely right. I mean, we do ensure that every single piece of the puzzle, we get copyrights assigned to us before we can actually mint or sell the NFTs as our own. As you correctly mentioned, even in a generative art, if we were using someone's AI in order to do the generation, we will also ensure that an agreement is being signed with a technology company to ensure that we have the right to use that for the purposes of our artworks. So I think that is an absolute necessity. I think one of the questions was whether, to what extent we need to ensure that we have everything in place before we mint the NFTs. And the answer is, you got to make sure that you have everything in place before you can mint the NFT. That must be the short answer.
100%. 100%. Somebody asked if you can access the metaverse in the US, does that mean the US has jurisdiction or only if the IP is materialized or transferred in some fashion by a recognizable asset. I don't understand the second half of that question, but the first half of that question, I think that one, real world treaties cover most of this stuff. So regardless of where you're located, if something's got a rights holder, a right title based on U.S. copyright or U.S. trademark, there are several international treaties that would make wherever you're located subject to that. I mean, it might be harder to enforce, but I think that's the answer there, is that it's really just meat-based law that covers that, and it's pretty well established. Ooh, this are you guys seeing this one? I'm sorry, I don't mean to kind of take over the talking here, but how would you structure a corporate entity overseas for an NFT project that would be considered a security? So we get this question all the time. Bianca, I'm sure you do as well. I think the answer is very carefully. U.S. law applies to U.S. citizens always. So no matter how much, and that goes for every jurisdiction, no matter how much structuring you do, the individuals involved always have some liability. But we do have a unique set of structures that we use at my firm that involve Cayman, BVI, and Seychelles entities to try to minimize the likelihood of enforcement, to sort of abrogate sort of the equity trail, and to take advantage of more permissive regulatory jurisdictions. But American law always applies to Americans, so it doesn't, just because you do those things and structure those things appropriately, doesn't mean you're outside the long arm of the SEC or the CFTC. So, or even of the Copyright Office, the Trademark Office. So I think that the answer there is consult with a lawyer who knows what they're doing. It doesn't have to be Bianca or me, but definitely make sure that your lawyer has Web3 experience and that you are appraised of the risks, because they are significant.
Yeah, and just to add, I mean, we've had experiences on our end as well, where we tried to do a project which was entirely in compliance with the regulations in Singapore, for example. But as long as a US citizen were to buy something from our project, we may be subject to US regulations, and that's what we've been told by our US counsel. And the only way we could, in a way, get around that is to be able to demonstrate that we've used all reasonable methods to ensure that a US citizen wouldn't have had the opportunity to buy, the asset that as part of the project. So it is a very, very strict rule. And Dave, you're absolutely right. I mean, as long as it involves a US citizen, just make sure that you're also in compliance with the US regulations. That would be my advice.
Yeah, the SEC may be very slow, but it certainly is the tortoise in the hare race. Like, slow and steady, man. These are immutable records that last forever on the blockchain, and some of the statute of limitations for this stuff is 14 years. So you may not get in any trouble for the first couple of years, but it's coming.
Exactly.
Lots of questions, but yeah, we have 5 minutes left. Yes, good questions. I guess, how do you vet an NFT lawyer? What are some questions to ask? How doesn't it become a money pit? Ask them what projects they represent. Yeah, that's a good idea. Asking who their clients are, who they worked with, but also asking ahead of the work to start, like, what are they actually going to do? What is the work they're going to do for you? And there are some things that are absolutely necessary, and others are kind of maybe not so urgent or necessary. So that could be a good way to go. But anyways, we still have a lot of questions. Maybe we can all drop our contact here if you guys want to email us, or I don't know. But thanks everyone for coming by. I'll let you guys maybe conclude?
I think my final piece of advice is what I just said. Like, make sure that you are talking to an experienced lawyer in the space. Second, almost as important, is make sure you're speaking with an experienced accountant in the space. I think those are actually harder to come by, to be honest. And to answer the questions about how do you vet people, vet lawyers, ask them how long they've been in the market, ask them to define an NFT for you, ask them to list some of their example projects, and make a gut-based decision at that point, because there isn't a lot. I mean, I've been doing this since 2016, and I don't have hundreds of clients that I can point to. I have dozens, but it's a brand new area, and so someone who's been in it since 2016, like myself, is actually like one of the oldest persons to be involved. I mean, really. I mean, there were lawyers who were involved in Bitcoin pre the ICO boom, but like very few and far between. So yeah, there's a lot of bad advice out there, and you got to suss through it to get good counsel. Manfred and Julian, you guys want to add anything?
I can only second what you said. Clearly, I think from a corporate perspective, obviously you generally work more through referrals, but in the space it's a bit more difficult. But I have to say, having talked to a number of, I would say, blue chip law firms in the US, and even there is no consistent view. Like, we asked different law firms, is that type of NFT, which is like a collectible type NFT, so not a security or anything, would you define it as a security or not? And we got some people who said, well, it could be, to others adamantly not. So it's a pretty difficult space to navigate, but and I think you also have to go a little bit with your gut with these things, that obviously, once the good credentials check out, that if you're knowledgeable yourself about the space, you can pretty easily see when a lawyer just is more of a corporate lawyer and doesn't really understand the organic nature of the space and just basically wants to put everything in boxes. And I think that's it works if you're a Fortune 500 company, but if you're a bit more entrepreneurial, and you want to find solutions at the end of the day, then you need to look for somebody who will just help you navigate the pitfalls, but provide you with answers, and not just say maybe, because that doesn't help anyone.
Yeah, and I would echo what everyone has said. Just my final advice is actually quite intuitive. Find a lawyer that can explain to you what the current regulations are in plain English. If you can understand him, then you've got a good lawyer. If you have no idea what he's saying, I think that's a red flag.
It's a good one.